Welcome back. You're watching Newscentre with me, Ashmit Kumar. Now, the Supreme Court has barred trial and civil courts from admitting or passing orders pertaining to cases of disputed religious sites. It has also barred against registration of any further suits against Places of Worship Act till further orders. A bench headed by a newly appointed CJI, Justice Sanjay Khanna, said that no proceedings will be ordered until the next date of hearing. The court has also given the centre 4 weeks' time to file a response to the pleas challenging the constitutionality of this act. The 1991 Act, importantly, prohibits the conversion of religious character of places of worship from their status as of August 15th, 1947. That's the cutoff to keep in mind. And joining me now is Mr. Sanjay Hegde. He continues from the first segment to this. He's still with us, the senior advocate with the Apex Court. Also joining us is Mr. Amitabh Sinha, also senior advocate with the Apex Court with the Supreme Court. Gentlemen, thank you once again for joining us. Mr. Hegde, to you first. Justice Khanna, while passing the interim order saying that we need to stay the hands of civil courts, of lower courts, faced very stiff opposition from some of the petitioners' lawyers in this case, especially from the Hindu side, saying that we've not even been heard, but the proceedings are being stayed. Firstly, on this this interim stay that has been granted, how important was it? Or could the lower courts have been allowed to continue while the Supreme Court decides on this subject?
If you allowed the lower courts to continue, how many more sambals did you want? How many more people did you want to die? That's what has happened. And it was an unfortunate remark from the bench in an earlier set of proceedings which gave life to all these suits. A constitution bench of 5 judges in Ayodhya had very clearly approved of the Places of Worship Act. Section 3 of it says that the character of all places of worship will remain frozen as on 15th August 1947. That is, if they were existent on 15th August 1947. And no suits could therefore have been entertained. They should have been dismissed at the threshold. Unfortunately, there was a remark which said that maybe you can ascertain what the character was. Yes, that was a conservative kind of approach that, okay, let people keep agitating this issue in the lower courts, and that it can be sorted out at some point of time in the future. But unfortunately, what started in one place became an epidemic. We have had a Bharat Khodo Yatra of litigation, and it has led to violence. The Supreme Court had no option but to step in. Secondly, and this is
no
more
option
important,
but to step in.
There's one more thing I want to say.
Cannot have. Yes,
there's just one more thing. The government of India had not filed a response to these petitions, despite several opportunities given. The government has to take a stance. Normally, the government has to defend whatever act is on the statute book, because otherwise they have the option of taking back the act. They can always repeal acts. So the government possibly did not want to disappoint its supporters by filing an affidavit. And this is also one of the reasons that the court said that in the absence of any defense, there will have to be a stay.
Right. So 2 key questions there. One of them, of course, government not filing its response. This petition was filed back in 2021. Still, we've not heard from the government on what the official stance is. That's the argument that Mr. Hegde was making. Mr. Sinha, coming to you now. Again, how important is it, the Apex Court's decision perhaps stemming from the violence that we've seen in Sambhal? Is this something that is perhaps best par for course as far as all stakeholders are concerned? Let the Supreme Court decide?
Ashmitji, it is very clear and a very established fact that when Supreme Court takes up any matter for the hearing or for consideration, other matters which are pending in different high courts or lower courts, they cease to operate. So this is a very common practice. Nothing is uncommon. And Supreme Court has taken cognizance and issued notice and asked the centre to file a reply within 4 weeks. So it's fine. Whether the centre files the reply or takes some more time, that is a matter which is to be decided by the centre. But I am here to discuss something different, Ashmit. Why I am trying to issue this point or raise this point? This basically this question in itself is open and shut case. I am not trying to you can say prejudice any person or any court or anything, but my point of view is very clear. See, in the Constitution, the Article 14 gives a right to equality to everybody. But in the Constitution itself, the doctrine of reservation is accepted in Article 15 and 16, Article 15 4 and Article 16 5.
Sure.
So all these things are very much there in the Supreme Court article. Why reservation is there? Because reservation basically is to heal the wounds created on the hearts or in the mind, on generation of Indian population, Indian citizens. So reservation was accepted, and till date reservation is a fact, and it is continuing. So just to healing the wound doctrine is applicable here also. So if either you accept the doctrine of reservation, it is good, proper and legal, or you accept that 1991 Places of Worship Act is good or legal. Those things cannot go together. If 1991 Places of Worship Act is good, then the doctrine of reservation.
Fair enough. So you're juxtaposing Article 14 with the 1991 Places of Worship Act, saying that both of them cannot survive together. If the right to equality is there, we cannot have 1991. That's the long and short of the argument. I'm just intervening to ask a supplementary question to you, Mr. Sinha. The question I want to ask you supplementary is that about the way forward, can there be a via media where perhaps there is an agreement between stakeholders on identifying a few sites, which is what Mr. Subramanian Swamy is saying in his application, that let's read the application, read the legislation down and not strike it off entirely. Let's agree on Mathura, let's agree on Varanasi, and let that be the end of it. Is there scope for via media?
See, so who will decide who is the stakeholder? That is the most important thing. Basically, the faith is important. Faith is the key word. If anybody's faith, any person's faith is there, and the faith gives this effort of fuel, that the survey should be there. He is not keeping law in his or her hands. So if he is pursuing legal course, why the court should not hear? The problem is they are not ready to accept the impartiality of judiciary. When the judiciary will be there and to look after whether this character of that particular shrine is to be decided. So what is the problem? It can be said that this is like chor ki dadi mein tinka. If the problem is there, except that that particular mosque or any other place of worship was basically built on the ruins or after demolishing some other place of worship. If it is so, then I think it should be established in front of everybody, and then other course of action should be decided. So if 1991 Places of Worship Act is there.
Right, Mr. Sinha, I'm afraid I'm just going to have to come in.
This is improper.
We're completely out of time, Mr. Sinha.
Just a minute. Ashmit ji, just a minute. When the reservation theory is there to heal the wounds of those people who had been oppressed and exploited earlier, so
yes,
the same
Mr. Sinha,
thing
that's
has
an important
with this type of
Mr.
case
Sinha,
also. It is not a matter
you've cited
of
reservation as a means. You've cited reservation as a means of ameliorating past historical hurt, and that is the argument that you're seeking to make. That's an argument that the Apex Court will be hearing and deciding on. But for now, the Supreme Court saying that we cannot have the civil courts playing a race with the Apex Court, so we need to stay the hands of lower courts. So that calls for a pause as far as Sambal, Mathura, Varanasi is concerned. There are about 10 religious sites which the Supreme Court has said no forward movement on, no further proceedings in that direction. But that's all the time that we have. Mr. Sinha, Mr. Hegde, thank you so much for joining us, being a part of this discussion. But for more news and updates, keep watching CNBC TV 18.